Excuse me. Oh, there's Jimmy. Hey, how's it going, Jimmy?
Good. How are you?
All right, my man.
Morning, Jimmy.
Sitting down in St. Pete's Beach.
Nice. Brings a smile to everybody's face.
Yeah.
We got Fred. Excellent. So Fred, we're getting YouTube started up here in about probably about 15 seconds from now. So
All right.
In a bit.
I'm looking over the one I just received from Jim this morning about an hour ago, and there's no X outs, and I don't see any additions to it, but
That's fine.
it looks exactly the same to me.
Maybe I printed the wrong one from the website then that I was looking at. So either way, from what a version that I had versus the version that's on, it's an improvement from what I had printed about a week ago or so. So.
Well, we should have that so we can discuss it.
And I've got mine. It's crossed out.
You do? Okay.
Oh.
Perfect.
Yeah.
Okay.
I mean,
Yeah.
It's the one you just.
So we are talking about
Oh.
two different things. We have
Okay,
both
two came in this morning. Gotcha.
Let me go ahead and get, I'll start the meeting and we'll talk about it. So
All right.
All right. So we're going to get started. This is Mike Harmer, Chair of the Dewey Beach Planning and Zoning Commission for our meeting here on December 5th that was posted, public posting for a public hearing and notice as far as an ordinance for the 5G telecommunication towers. So we had a draft ordinance posted, which we're going to talk about publicly, and we've gotten some public comments, etc. So to get started here, we'll go ahead and do the Pledge of Allegiance, and we'll take roll call. So let's get started with that. Pledge of Allegiance to the flag, United States of America,
to the
republic for which it stands, one nation, under God,
Indivisible.
justice for all. Thank you all. All right. Guess we want to adopt the agenda. So look for a motion to adopt the agenda. Anybody?
I'll motion to adopt the agenda.
All right, Rick, thank you very much. Seconded, and all in favor, aye? Aye. I don't hear any nays, so that takes care of the agenda. Roll call. I'll just start with myself for Marty's notes. Mike Harmer's here. Jimmy
O'Connor's here.
Marty's here.
Rick.
Rick
All
Judge is here.
So that's a quorum. And we also, I see that Commissioner Persinger's here, and we also have our attorney, Fred Townsend, and Ashley, who's helping us manage the meeting. So Ashley will let public folks in and out. But also the meeting has been, the Zoom meeting IDs posted so people can get in if they want to talk. We've had a couple comments, which I'll talk about in a minute. Let's go ahead and approve the past meeting minutes, the sets that Marty had emailed us both. Marty, you want to make a motion on that?
I make a motion that we adopt the minutes of the previous meeting as submitted in the draft. That previous meeting is Monday, October 12th, 2020.
I'll second it.
And I think all have been able to review them. And if there's any comments, changes, I ask for those now. Hearing none, take a vote on approval of the meeting minutes as Marty posted and we reviewed. All in favor, aye?
Aye.
Aye. I don't hear any, so it passes unanimously. Okay, so we're going to do a discussion amongst the commissioners on an ordinance to amend Chapter 185, Section 90, Utilities of the Code of the Town of Dewey Beach, Delaware, by adding a new Section 90A relating to wireless facilities. And we'll discuss amongst the planning and zoning commissioners, and then we'll start the public hearing and keep the commissioners meeting open to allow us dialogue. So, Rick, do you want to take the lead on talking about this? Are you okay with that?
Well, that's fine. I just, there are a lot of changes in something I received a couple minutes ago. So I'd like Fred to go over what the changes entail so we can have a more, besides sitting here for 10 minutes and trying to study this new
Yeah.
document, I'd rather just have the changes explained.
Right. Okay, well, I'd like to start with some preliminary remarks about just the state of regulation in this area. And then with respect to what we're doing today, we've got two different documents before us. One is the design standards, and I would hope that's where we could focus most of our attention today. The design standards, though, are referenced in an ordinance which had been posted prior to the commissioners meeting and sent down to you. That ordinance is what was recently circulated. Rick, that's what you're referring to. And I can talk about that generally, but where the rubber meets the road primarily is with respect to the design standards. And hopefully we'll focus on that and we'll hear what the public has to say about it. In general, this is a rather new area of regulation. It's been somewhat controversial. It's been the subject of some litigation, and it's taking shape in such a way that it appears that municipalities have been granted some authority to regulate the aesthetics of these wireless facilities. Those regulations, though, however, have to be reasonable, not discriminatory between providers of wireless facilities, and they have to be published. But we all know from our dealings in government, we've all been associated with this municipality or others, or just through our general knowledge of the law, that when you use the term reasonable, if that's the best term you've got, that is going to invite some disagreement as to what's reasonable and what's unreasonable. So it's not a series of objective tests that we're going to be applying to this industry, and therefore it's going to be challenging. It's been determined that we can't require all these facilities to be located underground. It's nonsensical that wireless facilities would be located underground, and that's just an extreme example of an unreasonable criteria to apply, which would in effect prevent or prohibit wireless facilities from operating, and we can't do that. Federal law has determined for us that these facilities can be located in existing rights of way, and the state of Delaware has passed legislation to that effect. And we are permitted to regulate wireless facilities in such a way that they are as least intrusive as possible. So I think the structure of the ordinance is to create design standards, which, if complied with, would trigger an administrative review as opposed to a conditional use review, which, as you know, involves the Planning Commission making a recommendation subject to a public hearing to the commissioners, who they themselves would be required to conduct a public hearing before granting or denying a permit. So we have some areas, the courts have told us there's some areas that we may be able to regulate in. However, they are not objective in many instances. One would be imposing a minimum distance between poles. A minimum distance between between poles or structures might be thought of in terms of aesthetics, but any regulation in that area is going to have to be reasonable so as not to actually prohibit another provider from providing service. So if we had an unreasonable minimum distance between poles and one of the providers was effectively prohibited from providing service, then we are potentially running afoul of the law. The same thing with the same side of the street. Aesthetically, it is generally favored that these facilities be located on the same side of the street as existing poles, so they're not scattered from one side to the other. But if you overlay same side of the street requirements on top of minimum distance requirements, you're potentially prohibiting a provider from installing their wireless facilities. So we have to be mindful of that. The federal law defines small wireless facilities as being 50 feet or less in height. We may be able to allow an administrative approval of new wireless facilities under 35 feet or under 50 feet. I think there's some effort to limit their height to 35 feet or less. We may be able to subject applications for facilities greater than 35 feet to a conditional use approval, or greater than 50 feet to a conditional use approval. I think we're going to need to hear from industry, and I hope we have industry representatives who are going to be speaking to us during the public hearing for their perspective. So those are just some general comments. I would ask you to refer to the document labeled design standards, and you may have one that says proposed revisions as of 11/30/2020. So this is largely the design standards that had been posted before the commissioner's last meeting with a few minor changes. I say minor in number. I don't know if they're minor in significance.
Call you back. Thank you. Thanks, bud.
So we are adding to our list of considerations public safety considerations, which I think are valid in terms of determining the location of new small cell wireless facilities. These design standards, as I said before, if met, would subject the applicant to a conditional or to a administrative review as opposed to a conditional use review. So it would be a more streamlined practice. Federal law dictates that applications have to be acted on within very short timeframes. I believe 90 days is the lengthiest time frame that would apply. So we can't effectively deny or frustrate the efforts of a provider in this area by stalling or by failing to promptly take into consideration the application and issuing an approval or a denial. The main change that I see on this design standards is under new structures. It's a bullet about 2/3 of the way down, which is restricting the maximum, which is purporting to restrict the maximum height of small cell or small wireless facilities to 35 feet from grade or upgrade, from grade, excuse me. And secondly, the concept of restricting the facilities from being installed so as to block or be too near to the entrance to the beaches. So that is defined in such a way as to find the midpoint of the beach entrances on the dunes, and requiring the facilities to be located no closer than 50 feet from that midpoint. I believe the definition of beach lands pursuant to our understanding with DelDOT is an area that we can regulate, and that begins approximately 8 feet from the end of the pavement at the end of each of the streets where they meet the dunes. So if there are any questions about the design standards, we can take them now, or we can discuss them now. We can also start the public hearing when you like. And as I said about the ordinance, the ordinance is what empowers us to adopt the design standards, to impose fees, to impose a conditional use process under certain circumstances. And it defines a number of the terms that apply in this industry. Both the ordinance and the design standards promote the idea of co-location when possible. I think we're going to hear from the industry that that's not favored. It's obviously favored for aesthetic reasons by us. We'll have to hear what their remarks are. And then, as you know, just again in general, your duty here is to consider the ordinance and the design standards and the public comment, and ultimately make a recommendation to the commissioners for final action on this initiative.
Well, I've got some questions on the standards. Just in general, the small cell facilities that we're talking about, that includes the 5G networks. That's probably the driver for this whole thing, is the interest in putting in 5G networks. I didn't see the design standards referenced in the ordinance. I don't know if I missed that, or that's in the new revised form or whatever, but I didn't see that. Also, the use of the acronym or ROW, I think that means right away, but it should be defined in the standards or the ordinance. It's not there. It's just used like an ROW. And these telecommunications towers, maximum height of 150 feet. Do we expect any of these in Dewey Beach? I mean, there's lots of antennas on the water tower, and if they need 150-foot antenna, I would imagine they would ask the county to put it on the water tower. That's outside of the Dewey Beach jurisdiction. Is that a reasonable? I mean, we're not going to have 150-foot towers in Dewey Beach.
No, Mark, or Marty, they're proposing, the 50, 35 really in the ordinance. So the 150 is spacing, that's horizontal spacing.
Excuse me, what was that?
The 150 feet is horizontal spacing, not vertical. So there won't be anything more than either 35 or 50 feet, depending on what.
Horizontal, you mean it's just a big wire?
Yeah,
antenna?
The 150 is just horizontal, like, from, like horizontally. But the 150, you won't see anything 150 feet high. They're saying 150 feet between telephone poles or whatever. So,
It says max height.
Yeah, I read it that way too, Mike, that it's 150 feet high.
No, that's not what it's going to be. The federal law, and Fred can clarify this, but the way the federal law reads, and we were being a little more restrictive than the federal law. And so we're going to talk about that in a minute. But the federal law says, where's the wording? I had it written down here. The maximum height shall be the greater of 50. I'd say the federal guidance, and this is what the town of Lewis and apparently reportedly adopted, shall be greater of 50 feet. So that's the maximum height, shall be a greater of 50 feet or an increase of 10% of the existing height. So, and we're saying 35 feet because of our 35-foot house, top rule. So the 150, the issue of 150 versus 300, we want 300. We're asking for 300-foot spacing because we don't want to see a bunch of poles. So that would cut the poles in half as far as horizontal spacing, Marty. So nothing will be 150 feet high. That's a horizontal. That's this, but the vertical height in the design standards, and that's talked about in section. I just had it. Where's it at?
So the design standards are applying for small cell wireless facilities, which are defined as the lesser height.
Correct.
But the telecommunication towers are defined as a maximum height of 150 feet. Is that an error? Should that be maximum length or maximum?
Are you in the definitions, Marty, of the ordinance?
No, that's on page 3 of the
Right.
standards where you talk about telecommunication towers.
I don't think we have any application or anticipate applications for towers, but you're right. The tower definition is 50 feet for telecommunications towers. What we're primarily interested in are these small cell wireless facilities, which are defined as 50 feet or less, I believe, in federal law.
Correct.
So we would assume or believe that there's not going to be one of these towers in an application in Dewey Beach. I mean, I can't imagine why they would do that. They can. There's plenty of room in Sussex County, including the water tower.
Mm-hmm.
No, they're already placing them. They're already about. Rick, I don't know if you have a count on how many are already in place. They've already drilled a couple of them in town. So,
Well, the small cell has been installed. I believe 7 of them are installed. All of them are atrocious. They're not even a fine piece of wooden pole. Our existing telephone poles put them to shame, and they're much higher than 35 feet. So this ordinance is very important to get on the books so the town has at least a say-so in the matter. When Fred, I realize you can't have a cell tower that's underground, but they need power to service them. And if they wanted to put a pole across the street from an existing power source, I would want to require the wiring hookup to the other pole to be underground, not an overhead wire across the street where it doesn't exist.
Yeah, that was intended just to be an extreme example of how we can overreach by imposing regulations which effectively prohibit the technology from being installed. So I understand that underground wiring and connection of one pole to another can and should be underground for aesthetics.
I didn't see that actually in the resolution or the ordinance, and I thought that was an important element to our town control. The 35 foot has been our max height limit for any structure in our town, with the one exception, and I think we should have a pretty good background to be able to maintain that as a max height. How many providers might there be in wanting to service Dewey Beach with 5G? Is it 2, 3, 5?
Rick, I would say it's probably above, it could be potentially above 5. Most likely it would be around 4 or 5 tops, but
And they all have NEC rights?
From what I understand is they're close to 40 wireless communications in the country.
And they all have a right to use our right of ways?
Technically, under federal legislation, it doesn't limit how many can be installed.
That seems to be quite a burden on a 22 block municipality.
Well, the reality is I doubt that that would happen, but you never know. I would suspect that right now we only have two providers, Verizon and Tilson. And, the bigger providers, Sprint, T-Mobile, might be at some point interested in coming in as well.
All right.
We
Then
have
the
heard
other,
from, we've heard from AT&T though, as well. We've heard from,
That's correct.
and do they share poles with any other local municipality? Rehoboth, Lewis, where
I
they
am not
are?
aware of anybody sharing polls at this point, and we've asked them to share, the ones that have submitted requests for installation of polls. It appears no one wants to share right at this point, or it's not available. They seem to come up with reasons as to why it won't work.
All right. All of our utility poles in the town at present are located on property corners. They're not in the front of a house or a commercial building. I presume that was a design standard for the utility companies when they were putting the poles in. I mean, some of these engineered locations for the coming poles seem to be right in front of residential homes, as opposed to a property corner where it is less inhibited to either a view or access to your ingress and egress. Is that something we can?
Our site visit, we did have some site visits, Rick, and some are on the corner side. If you're looking at from going towards the ocean, the end of the street, some are on the sides of both ends of the pavement. So technically, there's really no corner per se because they're right by the dunes.
Well, if you're bringing them 42 feet back from that, now you are directly in front of a residence.
Potentially, that's correct.
So Marty, I see where Marty's questions were, and I don't know why I didn't even put two and two together because I read this twice. But Marty, on the new structure section, we say it's not going to be higher than 35 feet for a new structure, and then when we go over to the maximum height standards, the tower should be 150 feet, no higher. It's got a height requirement. So Fred, how do you put those two together there? Because I mistakenly picked it.
no. So I think I could do a better job with the headings. But on the design standards, there is a series of bullets following new structures. But that's meant to be a subsection to placement and siting of small wireless facilities, which are defined by the federal government as 50 feet and less in height. Towers are different animal. And, we're getting some of these design standards from other jurisdictions who are regulating tower installations. Again, they're different than small wireless facilities.
Well, maybe we ought to propose that we have in Dewey Beach, we do not allow telecommunication towers.
I don't know that we can do that, but I don't know that I don't know that we have a realistic concern about the location of one of those on any of our streets, for instance. I don't know that there's a proper location for a tower. But we're not faced with applications for towers at the present time.
Yeah, I'm concerned about the fact of using public right-of-way. I mean, why don't we encourage the developers to buy private property for some of these facilities?
Well, the federal government and the state have enacted legislation which acknowledges this industry's right to locate these facilities in the public rights of way. And that's a starting point for us at the present time.
I mean, the rights of way were developed for, vehicular traffic and pedestrian traffic. They weren't developed for future technologies of any sort. And, You know, so you see these things getting crowded, you see the telephone poles in the middle of the sidewalks and so forth. And, you know, maybe that's a state legislature issue, not a Dewey Beach issue.
Marty, I want to butt in for a minute. Mark Norquist, he joined us about 5 minutes ago.
Yeah. Okay, good.
Sorry for the delay. Kind of tough time getting in down into Dewey.
Rob, Mark, we got it. All right, so Rick, you want to, is there anything else you want to mention about these design standards, or Fred or any other commission, as far as before we open up the public hearing? I'm going to be supporting, you know, a waiver provision somewhere, as requested by AT&T, but that might not be very popular. And of course, it's a democratic process, so it's up for discussion. For what we, you know, that'll give the town the ability, at least town hall, the ability to consider a waiver if we met up.
I just had I'm trying to correlate the resolution ordinance that I had read well, and now I'm taking this one. I don't find the new structure of void placement paragraph in the latest ordinance. Has that been removed? There was a line of void placement in front of commercial property or windows.
That's
That
in
line
that's in the design standards, I think.
All right, because I thought if that was still in there, the commercial and window frontage, it should also be including residences.
Yeah, so one of the
They're
bullets.
as important for residences than there are commercial structures in our town. So, and most of these installations seem to be beach block. So I think it's more important to stipulate a void placement directly in front of a residence.
Okay, so we
And
probably need to explore this idea of what it means, you know, when something is directly in front or when it's in, you know, not quite directly in front. I think that's a definitional issue we may have. I mean, you had mentioned earlier the prospect of requiring the poles to be on corners, maybe posting the or developing a standard that requires us to use the corner of property lines within a certain number of feet would achieve the goal that you were.
It would achieve the goal, and it's actually what exists. You'll see every telephone pole in town. It's on a property corner. It's actually a very good survey point for knowing where your property ends and where the right of way ends.
So,
Yeah.
so what I'm taking from
Yeah,
this is
different.
that you'd like to see that bullet revised to suggest that some maximum distance from a property corner would serve as the site for.
Correct. Something to that. If we have room to use that in our site location, I think that's an important element aesthetically for our property owners. And then there was another section that said view protection, which dealt with public parks and recreational areas. Again, I think that residences, commercial buildings should be included in view protection.
Rick, in that vein, on that bullet item, the way it reads right now, it says, as far as the first one you just talked about, in the design standards, says avoid placement in front of business entrances, windows, signs, etc. I had the same comment, and I'm going to read this to Fred and see if you and Fred and the other planning and zoning commissioners like this friendly edit. I had something to the effect of, Fred, I was talking about site plans. So let me word this for you. Let me say, so after etc., put the design. Let me see. All right, this is going to be you can wordsmith this later. But it says the design shall include view, and I call it de-enhancements. You can wordsmith that, but not a view enhancement. All right. The design should include view, de-enhancements, minimization analysis to assure maximum maintenance of views by residential properties where possible. Now, Rick, if you can, if you want to edit that to make it more restrictive or better, that I think the message you're trying to get across, Rick, is what I just stated. But I
Well,
might,
it is. It just that it seemed that the residential areas were left out of the
Yeah.
protection zones, and I wanted to point out that most of these are going to be affecting private property residences as opposed to commercial, but all should be protected.
so my
If they
idea,
have free reign to put in these poles wherever they feel they're easiest to dig a hole, and it happens to be right in front of somebody's, front porch, or if there was a better place for it in terms of not affecting a neighborhood, that needs to be a part of this ordinance.
yeah, maybe Fred, you can add with a desire to be near the property line instead of like in the middle of your property or something like that. But Fred, the words I gave you would give an analysis, and town hall could possibly expand upon that as an internal business process as far as what they mean by view analysis. And to me, what that means is you would look, okay, where the pole's going to go, and you would somebody would walk out to the site like the town planner who got this application, and expect that the AT&Ts and Verizons of the world, whoever's applying for these, would have on their application a analysis of somebody sitting on a balcony, on that property, making sure that they minimize the view de-enhancement. That would, to me, that's the only way you're going to do it, Rick. I don't see any other way, because it's either got to be either on a property line. I mean, it's got to be somewhere, and there's only property lines and properties, so, the best spot might be on near the property lines, but we should do a view enhancement or de-enhancement analysis based just some vector views of somebody sitting on a property. They could show the house on the property, and they could show angles of view. And I think that should be a requirement on the ocean side at least, because people, have nice views, and you put this big pole and birds are going to be sitting on it and stuff. I mean, it's going to be like, nightmare. So I think that might accomplish your intention without being overly restrictive. But I think Fred would have to, we give him, if we go with some kind of ordinance after the public hearing to give him some direction, we would say with the intent of the statements that we made as far as view de-enhancement analysis, and he would wordsmith that, send it back to us for what we would recommend if we recommend something to the commissioners out of this meeting.
Right. Well, let me ask, how quickly does this need to be on the books to have the town have some authority? I mean, if we're on a time schedule that council needs to approve it this month to be able to have a say next month, then we can't go back and forth.
Yeah.
Can I make a comment real quick? We've got a number of permit requests that have been submitted by both Verizon and Tilson that are before us right now. And I'm not quite sure how to process. Some of these we're asking for additional information as far as the permit application process. But I would like to comment, and I agree with a lot what Mike, you brought up about aesthetics, where we've gone out to actual site visits with Verizon and Tilson. Their response as to location and the reasons why they chose the location has to do with their band network and their range, which they say it's a certain amount. We've had I don't have an analysis that says that's accurate or not accurate. So that's what they've been pointing out to us. Whether that's real or not real, I don't have an answer for that. And that puts our town administration a little bit behind the eight ball. So some of these I'm asking for additional clarification, but I think we'd almost have to have an engineer or somebody who's a specialist in this area say, yes, this can be done, or no, it can't be done. But right now we're sort of at the mercy of the vendors that are coming into the town.
Well, I think Fred pointed out that 90 days is about as long a period that we can delay having an approval process. Do we need this ordinance in part of our code so that the town manager or the commissioners have this this meat to work with? When does this have to be done so that it works?
The latest permits that we've received, one from Tilson, we've got four or five from Tilson right now, which we have not accepted because in our position, they're not accurate. We've asked for additional information. They're not a completed permit. But they did submit 5 permits on October 20th that we have. And I sent a letter back to their attorney, basically saying is we can't accept them until we get additional information. So as far as the town is concerned at this point, the clock has not started for Tilson. Verizon has already installed poles, so that's, that ship has sailed. They have additional permits that we're asking for the ones for coming up. And we just recently got notification that the life-saving station pole from Verizon, we got approval from Denver that they could locate that. And we're not in disagreement as far as I know at this point from the town. But it's a question as to, how far we can push the Verizon ones that have already been installed. I don't know what we can do with that at this point.
Well, Jim, are these applications?
I'm sorry, Rick, but any new applications that come in, we're going to insist that they meet whatever our proposed ordinance is going to be. They've agreed to the 35-foot height. They've agreed to underground wiring for utility for access to power. They've agreed to that. The poles that we've seen from Verizon are wood poles that they've installed. The one in front of the life-saving station would be a metal pole similar to the one that they have in Fenwick at the Chamber of Commerce. Tilson has come in with metal poles that they're suggesting that we consider.
Does it seem that Verizon is one section of town and Tilson is another section, or are they competing on the same streets?
No, they're all separate sections, and you're right. One seems to have one section of the southern part of town, and Verizon seems to have included part of the Bayside as well as Route 1. Tilson predominantly is going into the ocean side, and that's where they're at. They're about 9 streets that they're interested in. Now, mind you, we haven't approved anything for Tilson at this point.
So Fred, what's our timeline to give the town this authority?
I don't have a definite answer to that, Rick. It's a legitimate question, but I'm not going to tell you that we have to move the ordinance up to the commissioners for that particular reason. I think this is a good discussion and it's an important consideration, but I want to avoid giving a direct answer to that question, unfortunately. At some point here, I presume we've got people who want to be heard on this subject in our waiting room. Is that right?
Let me first finish up with the commissioners. So,
Right.
commissioners, my guess is that we try to give Fred some direction today based on what's in front of us, and if we do get a waiver provision in there, that'll give the town hall the ability to back out of if we overstep the federal area, and we can always if we get it to the commissioners, the town commissioners, they can always send it back if town hall has some major problems with what we did today. And then, or they can and adopt it with some recommendations that they might get from town hall. That might be the best thing, the best path forward for today. Although we do know that this sort of sprung upon us, and it might not be a perfect document. As you can tell, it had some last minute edits. But if you're uncomfortable with any recommendations after we have the public hearing and we come back to deliberate, then that's fine. There's no strong feelings. I'm just saying, I think, my gut feeling is saying that the best thing to do for the town to protect us, as best as possible with what we got so far, is the research that's been done from town hall and helped develop this draft document with some edits like we've discussed, like maybe the residential view issue, and try to send it. But let's just hear the public, and we'll come back and deliberate, give you time to think about it while folks are talking. I do want to recognize that we did receive 2 documents before this meeting, public comments, and you all have those documents in your emails. One was from Verizon, and they changed the document, the design standards. And a lot of their comments were they wanted to insert like some words to the extent feasible type stuff. And a lot of that area, that's why I arrive at a waiver provision. I think the town needs to have a waiver provision that they can have the authority at town hall to do what they need to do to make sure they keep us out of any type of contentious situations that could violate a federal situation. And then give some flexibility, and the town hall is going to be protecting our view rights, because obviously our town commissioners and us are all concerned about that. And then that's really was my major. The other comment based on some of the things I saw were the wireless equipment we say should be a minimum. There was you talked about the size of it somewhere, and they said it the standard size like 4 feet high instead of 3 feet. It's like 15 inches by 4 feet. That might have come from AT&T, but both AT&T's and Verizon's were comments like that. A little bit concerned about overstepping. They're just trying to give us some friendly advice, it looked like, in some of those areas. For example, on AT&T's, where they're talking about placement and siting of small wireless facilities, they talk about the maximum height, our definition, versus the FCC order of September 26, 2018, where the extension height shall be the greater of 50 feet or an increase of 10% of the existing height. Fred, you might want to look into that. So if we come back to you after deliberation, we might say, look at that, Fred, and look at the residential view analysis issue. Just get something to town hall that they can work with, and or the town commissioners can consider after town hall gets to look at what we do today versus an edit going into town commissioners meeting, or they edit it during the town commissioners meeting. Anyway,
let me just make one comment maybe before we go public, but
yep.
It seems to me that, we said that where we have concrete and pavement and so forth, that it's unrealistic to have things underground, but certainly if there's something that's needed or desired on the ocean side, it's very easy to put cable underneath sand. And, we ought to maybe specify that is, oceanside wiring is underground.
Well, anywhere, Marty, they can do underground. It's called basically directional drilling, and they can do that if they're competent enough to not hit other utilities along the way. And there's all kinds of construction methods out there to make sure that doesn't happen. They do it all day long, all over the country, all over the world. So, Marty, that is a standard practice. If we lead them to say we want to put wires underground, that should not be a problem. We should not really see backhoes out there digging. I would assume they would try trenchless.
Yeah.
It's not that complicated for them to do
Right.
that.
Yeah, I think it's very straightforward. Well, good, thanks.
Yeah, no problem. All right, any comments from the commissioners, or we want to see what the public has to say and we'll come back and deliberate? Hearing none, we're going to keep the commissioners, the planning and zoning commissioners meeting kind of open where we can dialogue, and we'll look to Ashley to begin letting folks in, and we will go from there. All right, so that's what we're public hearing.
The only person that's in the waiting room at this time is Joe Divis from AT&T.
Great. All right, Joe, you're on as soon as Ashley lets you through the gate. Thanks, Ashley. Joe, if you're on, please announce your name, your role, your company, and you can go ahead and tell us what you want us to hear. And we did get your note, Joe, and we just discussed it, as you just heard probably on YouTube. I'm Mike Harmer, the chair, and you're up, Joe.
Well, good morning, commissioners, and thank you for allowing me to participate today. Yeah, I now have you on two screens here. I was told not to do the YouTube and the Zoom. I'll screw it up. So I try to follow directions, and I hope that this is an indicator. Yeah, we did submit some comments, and I did listen to the discussion, and I perhaps want to just address some things that I heard. One of the things I think one of the baseline comments we want to make is the need for small cells. And For AT&T since 2007, we've seen a 580,000% increase in wireless traffic. I think we can look at the pandemic, we can look even before the pandemic, how much more people are using wireless service, not just for talking, but for mission critical commerce, for things that are bandwidth heavy, for entertainment. And with the spectrum we have to continue to deal with that traffic, just like a highway. You know, you get too much traffic on a highway and it backs up and it slows down. Small cells.
Joe, you don't even need to tell us. We get it. There's a need.
Okay. All right. Well, but I think that it's important to understand why small cells are needed, not just for 5G. It also is just to move traffic on 4G and be off ramp. So I just want to make sure that is understood. I think it's also important to distinguish too between the players in this ecosystem. Verizon, AT&T, and T-Mobile are the providers of service in this area. Sprint has been absorbed by T-Mobile. I think I heard something that there are 40 providers in this country. There's really only 4 that are providing service in Delaware at this time. Tilson and others are infrastructure providers. They generally will work for companies like ours. So, when AT&T comes in, we will probably have someone like an NBNC that will be representing us, but they will be doing that on our behalf so that our small cells will provide service. So I just want to kind of maybe distinguish who the players are. When we're looking at where to locate, it's based upon the network calculations and the need and where we determine service is being disrupted or needs to be improved based upon our macro network, where those big, as you talked about, the big wireless facilities are. So it is very technical and data driven where we locate. Co-location is a term that's kind of 2 definitions on it. In the macro world, where we have the large facilities, it is where you put multiple carriers on the same facility. Co-location in small cells for us is when you put it on an existing pole, whether that's a utility pole, a light pole, a street light, things like that. In the small cell world, because there's not a lot of space, putting multiple carriers on a small cell pole is very difficult. We think is service disruptive. So we are not favorable to that. But if there's existing structures there and they can work, we will use them. Now, sometimes utility poles, such as electric poles, have certain primary power elements that make it prohibitive for us to use them because of the power company's restriction. The comments that we made, I think, do reflect some practical realities of what is in our control and what is not in our control, such as the equipment. We don't manufacture the equipment. If that is provided to us, we continue to work with manufacturers to make it as aesthetic as possible. But there are needs that we have based upon, or restrictions we have based upon the network facilities that we get. Distance between poles. I think to look at that, we asked for 150. I don't know if Verizon, I think, said 150 feet. I think we left it open, but the 300 feet was a little bit arbitrary. If you're talking about perhaps the same provider, 300 feet, that may work, but our needs of where our facilities may have to go versus Verizon's or T-Mobile's would be very different. And there might be a need to have them a little closer than 300 feet. Now, that then you bring upon that, using existing structures, things like that. But I think you do have to distinguish between providers and that our networks are not monolithic, and how our networks have developed over the years are different than the other providers. So that's where that 300 feet seems the definition of it is like across the board for any and all providers, whereas we may need something in an area that that Verizon may need something. And then, so we are then restricted, as was discussed earlier.
So
I think-
can I ask a question here?
Yes, sir. Yes, sir.
Thanks, Joe. So you're right. You pointed out that you're aware of Verizon's comments.
Yes, yeah. Mhm.
Right. So
Yeah.
Verizon on this particular subject is saying they can live with 150 feet of separation, but only between
Verizon.
Verizon poles.
Right, right.
So can you not support
Excuse me.
any minimum distance between your pole and a pole of another provider?
I think it all really, it's really dependent upon the needs of the network and what is determined to be sufficient for the customer service. I think we have no problem with what Verizon has submitted, if that helps answer the question.
But
Can I just ask, how far do you broadcast? How much room do you need before you have to install another pole? What's your broadcast distance?
It depends, Commissioner, on the need and the purpose of the small cell. A small cell for AT&T, if we are using it for capacity purposes, it may only be a block or two that we need to cover so that we can handle the additional traffic and make sure the traffic is moving smoothly. If you're talking 5G at millimeter wave, that may be a different calculation because of how the spectrum propagates.
Well, what are we talking about here?
I think it all depends on the purpose of what the small cell and what the carrier is trying to do with that.
What are you trying to do? I'm asking you what you're trying to do. How far?
Sir, I can't, unless we have, unless I have a specific plan from the engineers, I can only give you general answers.
Can I ask a question if that's okay?
Certainly.
Joe, what you just basically have stated is you're willing to go 150 feet between your pole, between your AT&T poles. Is that correct?
It's 150 feet from a Verizon, say if Verizon has something installed, okay, has a small cell installed, and we need something in that area, we can live with the 150-foot distance between what we would have and what Verizon would have.
Okay.
So let me follow up with that. So, for example, we've got some Verizon poles already at the end of the streets by the dunes. Therefore, AT&T would have to go 150 feet away from those poles. Is that what you're saying?
I think that, well, if that was in the rules, that we would have to follow that. And if we needed an exception, we would have to go through the process.
Okay, so I guess the question I have is then following up on that is, we've been told that from Verizon that they can't go any further away from the dunes because their range doesn't work. If that's the case, then how would your potential range work with AT&T unless you have a different, some sort of a different mechanical structure, electronic structure that allows your wavelengths to go further?
Well, I think, again, it all depends on what you're trying to accomplish with the small cells. I don't want to speak for Verizon because I don't represent Verizon.
I understand.
But not every small cell is going to do the same thing. So what we've done in Rehoboth, for example, is 4G is to increase the capacity of our 4G network with small cells. We are not providing 5G plus, as we call it, with small cells in Rehoboth. We are providing 5G with some of our other spectrum at our macro sites. What Verizon may be doing is doing their 4G or 5G, part of their 5G deployment at a certain spectrum, using certain spectrum, which then the propagation capabilities are different. So it really depends on what the provider is trying to do with the small cell or small cells that they are proposing. What are the needs of the network they are trying to accomplish so that they can serve their customers better?
Totally understand that. The question really comes back to the locality as to how many poles do we want, separate poles installed in an area? And I would imagine that if you were a property owner at the end of the dunes, you wouldn't want a series of 10 poles in front of your property in order to access whatever communications. And that's sort of the dilemma we're at now.
Yeah,
Okay, that's it for me. Thank you.
good. Thank you. Let's see, I wanted to, yeah, no, I think we concur with certainly what Verizon has proposed. I think it certainly matches what we have with respect to the ordinance. And I see that the ordinance has been amended some, and I don't know if haven't had a chance to look at that. I think the view protection language that Chairman Harmer proposed, I get it. I don't know how it sounds very subjective. And I think that's kind of the key. I think as your solicitor would probably see how you put something in writing that does, address community sensibilities against, what is, what doesn't prohibit service, and view protection. I think, as we stated in our letter, I don't know how you create an objective standard on that, so that it's not just what somebody feels or somebody thinks, which may be different than what somebody else thinks. We don't just, we're very particular as we look at the network and the metrics and the traffic, and try to also kind of look forward as to where we're going to see increased traffic, what we're going to need to do to make sure that we are providing service to our customers. And customers are, our public safety. You're going to do a lot of telemedicine with the pandemic. There's a lot of things that are mission critical that are being used in wireless technology. So it is important, just like what you have with any other utility or any other infrastructure, any other service, whether it's electric, gas, water, anything like that, or communications, connectivity. It is an important part of quality of life. Now, how you balance the infrastructure needed for that against, the need to make sure we're providing that service in a robust and appropriate way for how customers are using the technology now, is obviously where we're at. But we make these suggestions to you with all respect, the challenge you're facing to address the needs of your community, I will be glad to answer any questions to make sure that you have the best information I can provide you on how we look at the world and how we look at serving our customers and the communities.
Well, Joe, most all of our lots in Dewey Beach are 50 feet of street frontage.
Okay.
And there's maybe 24 homes per block. And I'm getting the feel that 150 feet works for you. So 20 or 30 feet shouldn't make any difference in the placement of the pole for the service for that particular neighborhood that you're trying to service, correct?
That probably is correct. Yes, sir.
So in other words, if you wanted to put a pole and it was deemed somewhat inappropriate for the neighborhood, but a 15-foot relocation of that pole, that wouldn't affect your service.
That's my understanding. Yes, sir.
Well, that's very good. Thanks.
All right. Appreciate it. Any other commissioners have any other questions? And then we'll move on to the next. We have 3 other people waiting, and we probably want to get moving.
And I'll stay on available if there's anything you need. Yes.
Can I ask a question to Mr. Divis real quick?
Yes, sir.
Go ahead, Fred.
So the design standards and the ordinance define small cell facilities, small cell wireless facilities. They refer to small wireless facility. What is the appropriate terminology so we could make them consistent?
Oh, boy. I don't know if that's a legal question or not. I am not a lawyer, I will tell you, just so we're all,
Well, maybe one of our next speakers will be able to speak to that, but that's one thing we want to,
Yeah, and I have to go back and look, I guess, in the, because actually, sir, you raised a good point about when it says all new wireless equipment shall be installed no closer than 50 feet from the midpoint. I don't know what is does that include if there is already say a light pole or something, and that would be prohibited from putting an antenna and a small box on there, or would that be construed as putting a new structure there? So I'll take a look at it while the next person's speaking and see if there's anything I can do to advise.
thank you.
All right.
Thank you.
Thank you very much, Joe. We appreciate all your input and want to make sure it's a transparent and public process where everybody gets to say what's happening. Ashley, if you can.
Can I ask one more thing?
Yeah, sure, Fred.
Sure. Mr. Harmer, you had said at one point that you were in favor of a waiver as argued by AT&T. I don't know that we heard what their position is with respect to a waiver. We do see that in the comments of Verizon, they're suggesting that virtually all of our criteria be prefaced with the phrase "to the extent feasible," which seems to work as a waiver. I don't know if that's acceptable to yourselves and the commissioners, but
Well, here's the wording, Fred. And if you look in Verizon's comments, the last page.
I misunderstood. I thought you said AT&T had.
I might have. I meant Verizon. I'm looking at Verizon's comments, the last page, and I looked at that wording and the waiver wording, and if we get to a motion, I would say that we include the Verizon waiver language and give Fred, give our solicitor,
I see.
ability to, wordsmith a little bit if you see it's needed, but that would give town hall some flexibility.
I see.
1 second on that. When we discussed this with Verizon, they basically rejected every proposal that we submitted for relocation. And this issue of where feasible is very subjective.
Yes.
And we need to tighten that up to some degree so that we understand what's feasible, and their feasibility versus the town's feasibility may not coincide. So that's a real gray area, and to us, it has not worked so far with our discussions with Verizon.
So Jim, would the town be able to live with a waiver provision?
I think as long as we come up what's reasonable for a waiver for us, but their reasonable versus our reasonable is always we're going to lock heads on that. I can see that right now.
Well,
yeah, with
what Mr. Dedes had said was that we don't have the scientific expertise to evaluate the representations made by the applicant. So when the applicant says that what we would like would materially inhibit deployment, or what I presume to be the service they're trying to provide, then they would not be required to comply with the design standards. That's industry's position. So apparently it's not worked well, or not worked to our benefit in instances where we have tried to implore industry to consider other locations than those that they claim that they need.
I don't see why we need to debate. It's the town's ordinance. It's what we want to put on the paper to protect our rights to our rights of ways. I don't think we need to negotiate our language.
Yeah, so we can.
I think there's going to be applications that are not acceptable in the sense that somebody can be extreme in their demands. Right. We've got 3 applications. We accept 2 of them. We reject 1 of them. That's a reasonable approach. If they can't deal, if they're not getting proper hardware or getting the infrastructure that's going to be suitable, and they want to do it cheaply and on the lam, it might not be appropriate that we approve that application.
Exactly. Yeah, the backup plan, if we don't go with the waiver language, is Board of Adjustment. So, there's another way in town they would go. Fred, but if we do get the waiver language in, we'll move on, with the other public hearing folks. But I'm thinking if we did get it in, that if we could use the quick check method that you use in the Board of Adjustment. We sort of use that back in my normal career. We use some of that concept in our waiver process, but you could wordsmith that. That's a pretty heavy lift, in the short stream. So for now, let's finish with the public hearing, and we can decide if we want to turn Fred loose on a waiver stab at just to give the town hall the flexibility, so they won't have to go through the Board of Adjustment and back. But either way works, because there is a way at the town to go through a variance of the town, whatever we implement or recommend to be implemented to the town hall.
Yeah.
You guys good with that? We'll hear the other 2 or 3 folks.
Well, I would say that the process is going to be either they meet our design standards or they go through the conditional use process.
Okay, that works fine.
Right. Mm-hmm.
Fine. Okay. All right. So I guess Ashley's going to let the next one in. We're going to try to get to it a little quicker if possible, but I don't think there's not that many there. We won't set a huge time limit. She's trying to tell them around 5 minutes. We got Kevin Moss. It looks like the name on. Okay. Kevin, if you can hear us, just introduce yourself and tell us what your role is and property address if you're a property owner.
Sure. Can you hear me?
Yep.
Oh, great. Thank you. So my name's Kevin Moss. I am a property owner, oceanfront property owner on Cullen Street, and part of the Seagate property, if you are familiar with that property. And I've spoken with some of the members of the council, Jim Dedes and Dale Cook, in the past about this issue. But first, I just want to thank you all as representatives of the residents of Dewey Beach. It's just a breath of fresh air to hear how your position really mirrors that of so many of the property owners here, all of the property owners that we want to preserve view corridors and, what we've come to love about Dewey Beach. So thank you all for working so hard on this issue. I came a little late to the meeting. I was in about 10 minutes late, but I did hear the tail end of some commentary relative to Verizon and potentially the ship having sailed on their poles. But the question I have for you is very specific, actually, just to Cullen Street. There is a Verizon pole that was installed on Cullen Street some months ago. It was installed over the dune lines, and DENREC got involved and tried to move that pole landward of those dune lines, or at least convince the Verizon folks to move that pole landward. They moved it once. They did not move it landward of the dune lines, and then DENREC got involved again and asked them and marked where it needed to be moved. The question I have for you, it still has not been moved yet. If this ordinance is put in place prior to them moving that pole now, would they then be subject to this new ordinance and they'd have to move that pole landward potentially up to, I heard, 46 feet of the dune line? Or do you believe that they're now sort of grandfathered in to move it just to the dune line? And have they put an application in to even move that with the town council?
That'd be Fred.
So that's a legal question that we're not really, I'm not gonna answer that. I'm sorry. I understand your interest in the answer to that, but I can't give you a definite answer. I don't think, I'm not sure that the ordinance as proposed would dictate that the pole be more than 46 feet from a location. I think the 50 foot from the midpoint of the entrance was designed to require that the pole be still in the right of way, which dictates that it's going to be no further than 8 feet from the end of a street. on that depth, if that makes sense.
That
But-
does.
Yeah. With regard to a particular pole and what standards apply in the future, we're certainly endeavoring to impose these standards, but I can't give you a definite answer to that question.
Okay, roger that. I appreciate that. Just what about the last question though? Have they contacted you about this specific pole? Can you answer that? And whether they intend to comply with DENREC's requirement to move it at least landward of the dune line?
Kevin, this is Jim Diddy's.
Jim.
That's news to me. I will contact Jennifer Pongress with DENREC to find out what the status is, since they're the ones that really determine where it can be installed as far as the DENREC building line. I would assume they're going to require them to move it, but I'll follow up on that.
Okay, I appreciate that. And the
Sure.
final thing is I have access to 5G engineers that work for me. If you all want us to weigh in on any questions, we can certainly help in that regard. So please utilize us as a resource.
Great, thank you.
So Kevin,
Okay.
can you give Ashley your contact information? If Ashley can get that, if you could Ashley and get that to Jim Deeds. If
Yep,
there's
he's
anything-
got it. He's got it. Jim
Yeah,
and
I've got that.
and
Thank
Dale,
you.
they've got it. Yep. But happy to help out. Okay, thanks again, everybody.
Anytime,
Really
Kevin.
appreciate all the work you do.
I hope we can get that pole out of the way because I walk down that street a lot. And it's quite annoying. All right, next person.
And it looks like the last person as of right now is Kate Carlson.
All right. Kate, we see you there. Your microphone is muted. So if you want to introduce your role, property address, if you're a property owner or company name, and what interests you have here. Kate, good morning.
Good morning. Thank you all. First, I'd like to echo Kevin's comments. I've been listening to the meeting this morning, and I'm a property owner on Oceanside Bellevue, a relatively new property owner. We purchased in October 2018. And so obviously, anything like this that's potentially detrimental to view is detrimental to property values. We're sensitive to that, but more so we purchased with the property with the intent to spend many, many years there with our family enjoying the current view. So I do appreciate the commission's sensitivity to these poles and what it potentially does both to the look of the streets and residents' views. I have some questions. There was commentary in the beginning about changes to the design standards. I have some questions about what that means relative to what has already been put in. So I've seen the pole on Clayton Street, and I don't know if there are any residents of Clayton Street on the phone, but it's not the most attractive.
I am property here.
It's not attractive. And so how do the new ordinance potentially protect the other poles proposed? And then I think I also heard relative to that, Verizon may be pushing back that they can only put these poles so far from the dune. So I just want to get some clarity on kind of the Clayton Street pole versus what is being proposed and what the timing is on some of this.
I'm not sure who could answer that. Would that be Jim or Fred, or who could answer this question? I can tell you the timing of this regulation or this action today. We're going to try to get an ordinance. I think we're going to try to get an ordinance in front of the town commissioners for recommendation. They have a town meeting December, I think it's like second week in December. You can look that up on the calendar. That's where the final decision will be made. If we get anything out of planning and zoning today, it'll only be a recommendation. And the second bite at the apple for yourself and other homeowners would be that day when they hear it at town as the town commissioners. All of us involved in planning and zoning. I'll speak for our other owners, other commissioners, and they can chime in and tell me I'm wrong, but I think all of us here, all the town commissioners, I would bet, are looking to preserve the view and the character of the town. And that's what the bottom line is. And then there's also the public safety aspect, which doesn't seem to be getting debated that much. I know that in my world as an engineer, the 5G regulation kind of went through the 5G work to me, feels like it's just being done, and there's not much that we can do with the federal law, but locally we can put these restrictions in and these things to assure that we get the best that we can. But the public safety aspect was kind of debated a little bit, and I'm not going to speak to it because I'm not an expert, but that is a concern also with the microwaves floating through the air and things like that, but that we don't have now, frankly. It's wires to your house, and then you put in wireless at your own, you make that decision. But the view is the most important, it seems like right now, in front of us. So these regulations, we're gonna look at them and try to put the best thing forward that you've read. It's been posted, and you can continue to listen here, and we will try to get the most restrictions that we can in. I was talking, did you hear my view analysis idea? Yeah, there's got to be a way that the town can at least force the companies to show that they've considered that. Look at each pole that you're putting and go pretend you're on somebody's balcony, and you don't want that pole right next to your balcony. It's like birds are gonna be flying up to the pole and stuff, and you won't be able to see. But there's going to be somebody's going to lose something out of it, I think, because
well, Mike, I'd almost like to ask the same question that she just asked. With our new design standards, how does it look different from what exists? I mean, you got a cubic foot there, you got a size here. I can't visually see what our design standards change from what already exists. And I think she wants a description of what's it going to look like with the new design standards.
Yeah, because I think I heard the push is going to be to move it about 50 feet from the mid of the dunes or something like that. And so, I don't know where it is on Clayton relative to where it would be under those design standards. And I think there's also going to be a new limit on height potentially.
Well, we're looking at 35 foot as a max height, and then it would be an additional 50 feet from where the dune walkway begins.
Okay.
Basically a 45-foot setback from the end of the paved road going shoreward.
But the one on
I
Clayton is basically
I don't know whether
right
the boxes become different on the poles themselves. They tend to be kind of funny looking metal boxes that for 5G you think they could be a little more sophisticated.
Agreed.
Indeed, we're by no means making an assignment to Town Hall, okay? But we just recently went through we went through the setbacks and all this, all the size of houses in the north end and all that. And we did some diagrams of existing, I don't know if it's possible, Jim, that going into the town meeting in December that maybe just, even if it's just a sketch, just show like what happened on Cullen, what we think is going to happen on Cullen. I don't know if any changes are going to happen on Clayton, but the homeowner, Mr. Moss, just said that there was something going to be moved because they did something that Denrec didn't like, on the dude. So I don't know if there's possible to show a sketch of what it is today versus what it's going to be, or on Clayton we could show what it is that they installed versus what this regulation would make it different, just for a demonstration purpose in the meeting. We don't have that today. Didn't really think of it. It would have been nice to have had it today, like we had for our deliberations that we had on the setbacks and all that stuff, the smaller houses. So anyway.
And then I had just one other question. I think I heard that the one of the life-saving station has already been approved.
No.
It will not replace the existing. No, it hasn't.
We haven't approved anything yet.
Okay. The proposal there is to replace the existing flagpole with a.
There is a proposal to replace the existing flagpole from Verizon. We did go, the mayor, myself, and our building inspector did go and look at the Chamber of Commerce flagpole that was installed by Verizon, and aesthetically it looked better than a wooden pole, and it would probably it would probably be more acceptable than what we've seen, what they've installed in the other street ends. But it is a metal pole. It's going to be at least 35 feet high, and it will, it's going to have their equipment installed at the top. But I suggest if you want to take a look at it, Fenwick is a nice place to take a look. Aesthetics and beauty is in the eyes of the beholder. So it's a very difficult tasked to say, to come up with some sort of a design. And I'd like to see a design no higher than 15 feet personally, but they're saying that's unacceptable. And that's where we get outgunned as far as what the electronic capabilities are of this, of the engineering that they've put in. So right now, we don't have an aesthetic quality that we can establish to the pole design. And I think that's what the chairman of our planning commission, Mike Harmer, is asking. You know, we can come up with some looks, but it's almost like I think we're going to need help to make sure that this is something that the community would like.
Mm-hmm. I actually lied. I do have two other questions. You know, the pole that's on Colon Street versus what Tillin is proposing, I think it's Tillin, with these small towers. What is the size of these small poles or whatever?
What they're proposing is not to exceed 35 feet, and it's a black metal pole that we've seen. That's what they've said. For me, it's probably nicer looking than the telephone poles that we've seen that Verizon installed. But that's me. The location is what I have the biggest problem with.
Right. Yeah, there's a lot oceanfront. And then finally, I think I heard that this is just Verizon's proposal. And so from here, there's going to be additive poles for Sprint, AT&T, T-Mobile. Is that accurate? That seems like a lot.
We've got the only companies that have come to us so far are Verizon and Tilson. Now, Tilson is an infrastructure company, as Joe Dibba explained, but they are allowed to install because they have wireless communications. So that's why they're eligible to come up. We have not seen that as of this point as far as what their wireless communication. I've asked for clarification. Will they have Wi-Fi set up for it or not? Or are they just going to put up a pole in hopes that somebody comes and leases the pole from them?
Okay. Well, thank you so much for addressing some questions. Like I said at the beginning, I do appreciate the commission's sensitivity to this on behalf of the residents.
Absolutely. We'll try not to disappoint.
Thank you.
So Ashley, is there any more?
There is no one else in the waiting room right now.
All right, so we'll close the public hearing and go back to deliberation with the planning and zoning commissioners and town and our attorney and Jim. So I guess Jim, as far as going into the town meeting, I don't know if Mr. Moss, maybe you could, he's offering his 5G engineers, maybe they could give you a couple renderings like we did, with the how we showed like sizes of houses and stuff. Maybe we could show, different types of poles that are out there in the world available. Mr. Moss could give us, maybe put his flavor on what a beachy pole would look like versus non-beachy. It might be able to help you guys if we get something out of here today. So just a suggestion. It was nice of Mr. Moss to offer his expertise he has access to, so maybe we can take advantage of that. Anyway, all right, cool. So I'm going to be quiet. Rick, anybody, any of our commissioners want to say anything?
I just kind of like to sum up. I think we are all 100% on the same page here. Yep. It's just a matter of Fred being able to do the hard work of putting it in writing so that all of these issues that we care about and are trying to protect can be done in the best method. I don't think it's way out of our line to be writing the paragraphs for this ordinance. But the essence of what we're trying to achieve is completely agreed upon by everybody within the town, and which is a nice thing. Finally, we have an issue that 1,000% approval is in our favor, but we need to write it strongly and correctly. So that's Fred's job.
Rick, so Fred's been doing a lot of work on this, and I think that what I would like to see is a motion to send a recommendation to the town commissioners of the ordinance and design standards, as we talked about today, with giving Fred the latitude to wordsmith a little bit with the intentions of what he's heard, and then to have one planning and zoning commissioner to work, offline. Well, two would be me and another, and that'd probably be you, Rick. Once Fred gets a draft of what we propose, like we've done in the past, we just read it once and say, okay, and then he sends that as our recommendation. That's what I'd like to see today. If possible, if our commissioners who are here agree with that and our attorney doesn't see anything wrong with that.
Yeah, no, I think that's a good approach. I think it would be difficult for us to wordsmith the ordinance, I believe, at this meeting here, but certainly maybe we could convey some of the summary points like Rick was talking about and ask Mr. Townsend to include that in the rewrite. Would that be appropriate?
Fred?
Oh, that's a question for me. Well, what I'd like to do is at least hit some of these points that industry suggested on the design standards first. I don't think it would take us very long if I could just take you through them.
Sure.
So Verizon is suggesting that we preface all these design standards with this concept of to the extent that they are feasible. And I think what they mean by that is feasible within the tolerances of their requirements, which we're really not in a good position to judge. Mr. Dedes has said that. He said, how do we counter their argument that their facilities have to be located in a particular place when we don't have the science available to us to evaluate that representation.
Yeah, I mean, I think we could put in some wording like using the best equipment available or something of that sort. In other words, it's not the cheapest equipment available, but it's the most appropriate, or the fact is they might have to spend additional money to get the things that we're asking for. That doesn't mean it's unreasonable. It just means that they need to spend a little more money.
Okay, well, being specific, they've asked that the language that relates to antenna in the first paragraph be prefaced with the phrase "to the extent feasible." Do you want to recommend that to the commissioners or not?
No, I think it's our ordinance and we don't have to be told how to write it.
Okay.
It should be feasible at all.
So that's my question. Then
that's just one person's comment.
Okay. Well, I mean, we also heard from Mr. Divis, who said that he supports the comments made by Verizon in the form of this ordinance. The submission that they made, not verbal comments, but they submitted something in writing. There's language at the end of that section that was proposed by Verizon saying panel antenna shall also be permitted. Do we know what that means?
Can you repeat that? Can you repeat that? I didn't understand that.
Well, it's on the industry, it's on the design standards, and it's a comment made by Verizon, and the language is underlined. It reads, panel antenna shall also be permitted. I believe that is a suggestion of theirs.
No idea what a panel antenna is.
Okay.
Yeah, Ashley, would it be appropriate to bring the guy from AT&T back, Joe, to answer that question for us, because he's in the.
Well, let's hold that one until we get through, because we might have more than one. Okay, so I presume then that we didn't like that to the extent feasible premise for antenna. We're not going to like it anywhere else. So their next suggestion was as relates to the regulation of cabinets and equipment. So we're not in favor of that. Is that correct?
I believe so. Maybe you could repeat that again. I think we're not in favor of that. I'm not in favor of that.
Okay. Mr. Seitz, do you have a copy of the Verizon comments?
No, I've never seen them, frankly. I don't know.
Are they posted?
Yeah, we emailed them. I emailed them to you a couple of days ago, the Verizon one. So they're in one of somebody's emails.
Okay, yeah. So what I did is I checked the meeting materials that were there, and that was the standards and the ordinance. Yeah, so I need to look at that.
Okay, so the next suggested edit was that to the language that reads, the cabinet shall not exceed 28 cubic feet in volume And their comment is that that volume restriction needs to match the FCC's definition of small wireless facility. So let's check that for Mr. Divis as well, if he's still with us. That's another question we'll have for him. One thing that did come up under the placement and siting of small wireless facilities, subsection B, Verizon was suggesting that they would not locate any of their own small cell antenna or wireless equipment within 150 feet of their own equipment. But I think Mr. Divis from AT&T made it pretty clear that he could live with a restriction of 150 feet between their equipment and the equipment of another provider. So,
Fred, can I comment on that? Right now, we've noticed that Verizon is at least 300 feet from their pole locations. So I don't know that that's an overly restrictive line, unless Mr. Divis can say AT&T can't match that.
well, it depends on what we're talking about. It's okay if Verizon's suggesting that they measure the feet between their own poles,
Right.
as opposed to their proposed poles and a pole proposed or existing owned by somebody else.
Well, I think AT&T, and correct me if I'm wrong, Mr. Divis, is that you were only referencing your own poles.
No, I think
No, he wasn't.
no. Well, as I took it, and if we can get him back on the phone, we'll confirm it. But I believe in response to a question asked by Rick, he said he probably wouldn't need to locate anything any nearer than 150 feet to any other pole provider or any other service provider's facilities.
That's the way I understood it too, Fred.
Mhm.
And just, gentlemen, just for a quick, I just got a warning. My data usage is about to expire. I'm international, and it's been an expensive meeting. If I disappear, I didn't quit. I just got cut off.
Okay.
Okay.
Well, if that's the interpretation, then I stand corrected. on
So,
that. But
We're going to do this then, if we keep Rick on, because we need him, because we have as far as the majority. Let's see, Mark, me. Yeah, we can deal without Rick. We're good.
All right.
but we can't afford to lose any any help on this subject. We're undermanned as it is. So what do we think about this then? Verizon that suggested 150 feet from any of the poles that they own or any of the facilities that they own. I believe Mr. Divis said 150 feet between poles, regardless of who owns them.
Yeah, he said he was okay that he could be within 150 feet of a Verizon pole.
Or outside that distance, right?
Yeah.
Yeah. So are we, how do we want to, how do we come down on that? 150 feet between poles, no matter who owns them?
Sounds reasonable.
I'm okay with
Okay.
that.
hey, Fred, I just have a comment to make. You know, the legislation calls for co-location of poles, right? And communication equipment. How come they can co-locate on one pole, but they have to be at least a minimum of 150 feet? It just doesn't make sense to me.
Well, we heard Mr. Divis talk about that. He said you can't co-locate on power poles, he's saying. You can't.
No, that part,
You can't co-locate on small cell wireless facilities, which is different from co-locating on these tower structures and water towers.
well, it defeats the purpose of to encourage them to co-locate. Well,
I don't think he said we can't. I think he said there could be problematic. He didn't use the word problematic, but sometimes they don't work with each other, but he did not say he can't.
and that's sort of the explanation we got from Verizon. That it's very difficult to co-locate. So I mean,
The answer is they don't want to.
They don't
that's
want
the
to.
bottom line. I think that is the bottom line. They don't want to.
Well, I don't know that we can require it. the ordinance encourages it.
Yes.
All right. Maximum height. We're
Should go with our town standard of 35 feet.
Yeah, that seems appropriate. I think
all
that's
right.
good.
Okay. Um, And then there was one more comment under removal, repair, or removal of all structures and or equipment owned by the wireless provider shall be done by and at the expense of the wireless company. So I think that's more of a housekeeping suggestion, that if it's owned by the provider, then the provider has to remove it once it's no longer in use. Whereas if it's owned by one of these infrastructure companies, it's their responsibility to deal with it, not the wireless company.
So how long does it take to become a white elephant? If Tilson puts a pole in and nobody uses it for 2 years, is it deemed removable? I mean, how do you formulate when it's to be taken away?
I think our administration's position is there needs to be some commitment that there's going to be a provider on the infrastructure.
Yeah. No, I think it's certainly appropriate to have that phrase and that requirement. I guess I'm concerned about implementing. I mean, how does the town know that a tower is not being used or hasn't been used intermittently? Maybe it would qualify as being used. We just don't know what's being transmitted from a tower. But I think it's good to have that requirement in there, because if we discover that a pole is not being used or it's tilted over because of a wind damage, windstorm, and nobody cares, that's a big problem. That needs to be removed.
I think the town, I think that would be hard to wordsmith that. I think the town has an obligation to do an investigation and to get answers. And in the event that satisfactory answer is not provided, then we could order the pole to be removed, I suppose.
Right. Yeah. Right. Good.
Damn it.
Can I make a suggestion that we put like within 90 days, something that if it's not used within 90 days, it has to be released? Put something down in the books, because if we don't have anything, then we're kind of at a loss. 6 months, something.
Why don't you try to throw in the words, Fred, just throw in 6 months, just so the town has something to work with. Is that fair, Jim?
I would think so.
Well, that might even be too long, I would think.
How about 90 days?
Go to 90. Yeah, go to 90.
Any pole installed on our right of way in town of Dewey Beach must have service provided within 90 days or will be removed.
And then, of course, any structure that presents a hazard, due to its, having been damaged or something would arguably have to be removed sooner than that. So we'll need to wordsmith that removal language a little bit, but I think that's doable.
Yeah, but it's a non-service pole that I think is our immediate concern.
So Ashley's got Joe from AT&T that's volunteering to answer some questions that we had. If you guys want to hear them, we can let them back in if that's allowed, Fred.
Yes.
All right. So if you're okay, let's get through your document first, Fred. Let's get everything.
I think that's it. That's all I think I have.
All right. So we'll be ready when we hear from him. So Ashley, if you'll let him come in and answer those questions like the panel antenna or whatever.
Right.
So I'm gonna set some ground rules, Joe. Let's just keep you like 5 minutes or less here. And just specifically, you heard some of the questions, Joe. Appreciate you sticking around. It's very important to us to get this as right as possible at this point.
Yeah. The panel antennas, I think that it really goes to the equipment manufacturer and what they provide to us in order to provide service. So it's really, in some ways, not up to us. It really is the equipment manufacturer and the vendor that we use. So I think that it's just an inclusive definition and making sure that it's not prescriptive, that you're essentially telling us what vendor to use. I think that's acceptable.
Well,
Again,
could you tell us what panel antenna is? I mean, maybe I'm the only one who doesn't know.
I'm going to make an analogy, and it may not be. If you look, a panel antenna is different than a canister antenna. If you look at some of our small cells, it's a cantenna. It's at the top of the pole, and it's cylindrical. A panel antenna can then maybe be at the top of the pole, but say there might be 3 small panels that would look like, a box, look like a rectangle, and then provide service that way. So it really depends upon the frequencies that are being used and the vendor with which we're using. So it's really, I think, more just so that there's not an inadvertent restriction on the equipment that can be used to provide the service.
Thank you.
Really, it's the equipment we use is based upon the need that we're trying to serve. It's not necessarily a cost thing. It really is the vendors that we're using to provide the service. So the other thing that I want to go on is the spacing. I think what Verizon, their amendment is good because it clarified that the space between my poles, say as AT&T poles, should be, that's the restriction as opposed to restricting where my pole should be versus where Verizon's pole should be. That's where I thought the Verizon clarification was a good one because it basically said you as carrier X can't just put things all in a line that are so close to each other that it's ridiculous. That's where I think their clarification was in that language.
Joe, can I ask you a question?
Yes, sir.
Verizon puts up a 35-foot pole. Their equipment. Can you co-locate on the existing pole?
No.
That's my point. That's the point that bothers us the most is we assume that this legislation would encourage the co-location, but you can't co-locate. Well,
co-location can have two different definitions, Jim. One is that if there's something that's already there, whether it's a utility pole or a street light, something of that nature, that we can locate on something that's there. Some utility poles, some electric poles we can use.
Okay.
Some we can't because the power company will prohibit us.
I guess what you're saying is you can't co-locate on an existing wireless communication pole.
Where somebody else is, yes, because the antennas are going to be too close together and it's going to create interference.
I think that's the fear that the community has is if Verizon's at one pole, you can't co-locate on that pole. You have to set up a separate pole.
Mm-hmm.
Okay.
And you can't commit to being 150 feet from the Verizon pole.
I guess, I wanted to just clarify, and I'll go back. Let me go back and just check with my folks. But I think that the Verizon language is a good clarification because it leaves, it does leave open the how we work against each other or with each other as providers and what our networks are, what the needs are of our networks, which are can be very different. They can be similar, they can be different. So I would like to, as they say, revise and extend my remarks and just go back and just double check on that 150 foot from another provider's pole versus restricting how close the same provider's poles can be, if that makes sense.
Okay.
Okay.
Different subject.
Yes, sir.
We marked the restriction against cubic feet of the cabinet exceeding 28. Can you help us with that?
I think that our advice and recommendation was that it should mirror the FCC definition on the size of the cabinet or the equipment.
So we could do that by simply saying that the cabinet size shall comply with the FCC's definition of small wireless facility?
Yes, yes, yeah.
Okay.
Brett, I would add to the minimum standard as required by the FCC.
Or the maximum standard.
Yeah, versus the maximum. We want the minimum.
That's simply so that we have a standard we can use across multiple jurisdictions. We have thousands of communities with which we're trying to provide service.
Okay, but what we're doing is we are restricting the maximum size. So we're saying that the cabinet shall not exceed the maximum size permitted by the FCC, or as provided by the FCC's definition of small wireless facility. I think that's
I believe that is let me just, I have multiple documents here myself. Let's see.
It seems to me if the FCC has put a maximum, how can you exceed it?
Right. I think Fred, I think what Jim D's trying to get to is that we want to encourage the minimum size.
Correct.
If there's a band of sizes at the federal level, we encourage the minimum. I don't know we're allowed to regulate it to the minimum. We could try to do that,
but when it comes to regulating something, you can see how that section H is written. It says the cabinet shall not exceed.
Yeah.
So it wouldn't make any sense to say the cabinet shall not exceed the minimum volume. This has to be written in terms of the cabinet not exceeding a maximum volume. So that's the clarification I'm trying to make.
All right. So, Joe, I think we're good.
Yeah.
We're all right. So, thank you.
I believe it says the restrictions should match what Verizon had indicated. I think is certainly practical. I'm sorry to interrupt.
No, that's all right. I think we're both saying the same thing. So,
yeah,
I think we're done with you. Thank you, Joe, for sticking around. You're welcome.
My pleasure.
Tell Ashley if you have anything else, but
Okay.
we're going to go ahead and deliberate.
Okay.
Just done.
Thank you.
Thank you very much.
Very much.
All right, so I think we're back. Fred and Rick were having some dialogue. I'm sorry. Fred and Rick were. So, Rick, Fred, you had gotten to the end of the design standards, and we got the ordinance. So now I think we're looking for a motion to give Fred some latitude unless we have any more discussion.
So the last thing then that we have on the design standards is this question of whether it's 150 feet between poles owned by the same company or 150 feet between poles regardless of who owns them. And I'm saying poles, but I'm referring to small cell wireless facilities. So what is your pleasure on that subject?
If that distance is acceptable to AT&T and obviously to Verizon, then that would minimize the number of poles on a town block if they had to be 150 feet apart from each other.
No, that's not what he said. He came back and he clarified that he's saying he'll keep his poles 150 feet from his poles. And Verizon will keep their poles 150 feet from their Verizon poles. But that doesn't mean that there's going to be 150 feet between all the poles. In fact, there's no minimum distance between poles. If you've got 5 providers, they could all be lined up next to one another. And that's what I think you're objecting to.
I am. And I would like if we could somehow regulate a minimum distance between any 2 small cell wireless poles.
Well, I think that's the last remaining question we have on the design standards is are we going to impose a minimum distance between the facilities regardless of who owns them, and what should that be?
Go ahead, Rick.
What is the average telephone or power pole on a city block? Do we have 4 on a block? Do we have 8? I mean, let's look at what we already have existing and imagine how much more we can absorb. I mean, I don't know. Are there 4 poles on a block?
Well, it's 150 feet is three lots, three front lots. So it's nine lots per.
Well, that's
lot.
with 150 feet. I don't think PP&L ever had restrictions like this. So the poles that are in existence, I'm saying, how many on average do we have on a town block?
That's a tough question, but you know, that's apples and oranges, Rick, because we're talking about poles, but we're talking about underground connections now. So you're going to limit poles because the utility lines are going to all have to be underground. I would recommend respectfully that we stick to the 150 foot.
I'm okay with that.
Yeah, I'm okay with that.
Okay. So what we'd essentially be doing is reducing the restriction from 300 feet to 150 feet, but we're not including the provision that the limitation applies only to facilities owned by the same provider.
Right.
So, yeah, so I think you're ready to move the design standards with those comments. And then we need to just turn to the ordinance.
All right, thank you, Fred. So the ordinance that we have in front of us is the one that was that we emailed this morning, and I see some changes in there. It looks like they're made by Town Hall, and I was able to notice that the things that I wanted in there got in there, at least the main one, and that is that we didn't reference in the ordinance the design standards, and they were added. Design standards: all wireless facilities shall comply with the town's design standards. That's the one comment that I had that was incorporated, and there's it looks like some clarifications that they made, and I say that if you're comfortable with making a motion that both the ordinance as sent and as the design standards as discussed would be what we're looking for. Otherwise, we can go through a couple more of the changes. If anyone else wants to go through those, we can do that. It's your call as far as commissioners.
I'm comfortable the way it is, but I would like to add the word residence to a couple of those location paragraphs.
Okay.
That's back in the design standards, and I understood that comment.
Okay.
Mhm.
Okay.
One final for me, and I will be quiet. The design standards are good the way we are suggesting them, but nothing aesthetically tells us, do you want a metal pole? Do you want a wood pole? Do you want a fiberglass pole hooked up? That's where some of this is going to come back when we look at poles and that people are, that these companies are going to be suggesting. Do we have any criteria that the commissioners would like us to look at from the town hall perspective?
The best aesthetically appropriate pole, I think, is kind of what we're talking about.
All right. I mean, if you will leave it up to town hall, we'll come up with something. But,
Okay. Yeah, I'd like to
Well,
also.
I'm not sure that we have the authority to say that poles have to be constructed of architectural, metal versus wood. I think that subject has.
I understand that, but that's going to be a question that's going to obviously hit town hall at some point.
Mhm.
I'd like to make sure we emphasize that we're encouraging underground wiring, not only for the power supplies, but for data transmissions. And, we don't concede that everything needs to be up in the air, especially on the ocean side where you don't have the pavements and the sidewalks that you do on the street side. So let's not concede that everything's going to be above ground.
Well, it would just be whatever's attached to the pole that would be above ground. When it reaches there'd be no overhead wires across any streets, but there would be wires going up and down the poles to the panels.
On the street side. And
make it clear, we're not approving any overhead utility wires for any new construction.
Mhm.
Good.
Right.
And that's one of the tests, that we're not regulating this industry in a manner which differs from other industries,
Exactly.
other utilities.
All right.
All right, looking for Commissioner to make a motion to move these two documents to the town commissioners. I think that will give Fred some latitude to clean it up, and Rick will be assigned along with myself. So Fred, once you get that revised based on today's discussions, if a motion is made and if a motion is passed, to recommend these.
Do we have I would make a motion that we do as you specified, Mike.
Okay.
I'll second that.
By Rick. All in favor? Let's do a verbal by each commissioner. So let's go ahead and hear from. I'll go down the list here. Marty, you made a motion?
I approve the motion.
All right, Rick.
Approve.
Jimmy O'Connor.
I approve the motion.
All right, Mark Nordquist. Mark, I think you're muted. Is what
Muted.
you're telling. So while you're unmuting, Mark, if you're still there, we'll look for you to tell us whether you approve or not. And I'll go ahead and say that my vote will be I approve, and I have no comments to add. So, Mark, are you still there? It looks like you're not able to unmute. So we'll take you and abstain unless you come back. But we pretty much have enough to pass it right now. We have the majority anyway, Fred, if that's allowed. Since Mark can't dial in with the technology, even if he said no, it's going to pass. So the motion passes with 4 and 1 abstain. How's that sound, Fred? Is that allowed? All right. So with that being said, Rick, Fred, wait to see your email. Looks like
I approve.
Yeah. Okay. So Mark approves. So that's unanimous.
Sorry about that. I was trying to bring it back up.
All right. So it's unanimous. We'll make the recommendation as Marty and Rick seconded. And what we will do is we will wait to see the final revision from Fred. And full transparency here. We'll wait to see the final revision from Fred. Rick will have first stab, and then I'll take a second look, and we'll get that to the town commissioner. I think they've already posted this on their agenda in case that we did make a recommendation. Jim Deeds, do you see anything else that we overlooked before?
No, sir. No, sir. Thank you.
All right, Gary Persinger, any comments by you?
Just a quick one. I think what we posted was just an update when you're meeting today. I don't think we have anything scheduled for a formal vote.
Okay, so we will go ahead and get something as far as an update. It'll be Rick, myself, or whoever's available at the time, and we'll put the report out. It's going to be something Mike can work with. Other than that, any commissioners have any comments before we look for a motion to adjourn? I have no comments.
No comment.
No comment. Thank you.
All right. See.
Motion to adjourn.
I second it.
All right. That was Jimmy O. Seconded. All in favor, aye.